Lawyers, what's the strangest law that actually helped you win? Story 1. In 2016, a prison inmate, John Modi, was charged with escaping from the prison in which he was incarcerated, which is a crime in Ohio. The prosecution, however, failed to establish that the Hawking Correctional Facility, and therefore the crime, was located within the court's jurisdiction of Hawking County, as all witnesses potentially able to offer testimony on the prison's location had gone home for the day. And incredibly, no one remaining could provide references allowing the court to take judicial note of the prison's location. The charges against Modi were dismissed, and he was allowed to return to prison to serve his sentence, but at least without additional charges. Story 2. Not a lawyer, but I got a charge dropped because of the cop's bad handwriting. I got a ticket on a Monday night for speeding and was given the court date of like 2 months from then. About a week and a half later, I get a letter in the mail that I'm being charged with a failure to appear for court. I'm in court 2 days later for that and tell the judge I'm not guilty on the FTA and no contest on the speeding. After asking him to just look at the date on the ticket and my supposed original court date, he sets them down and goes, "You have a point there. Not guilty on the failure to appear. And how do you plead for the speeding charge?" I replied, "No contest. I was speeding, Your Honor." He looks at the ticket, sees the cop had initially put 10 over, and in the notes put my actual speed like 20 or 30 and goes, "Yes, it certainly looks that way." Story 3. I used to haul produce from my neighbors who had a small vegetable farm to the farmer's market and then sell it in the mornings and come back in the afternoons. On Memorial Day weekend, coming back from the market, they had a DUI checkpoint in the afternoon. I didn't have my license with me because I had forgotten my wallet that morning, so they wrote me a ticket for not having my license. But they wrote the ticket to the owner of the truck and not to me. When I got to court, I was standing in line next to the cop, and right before we walked up to the judge, I whispered, "I'm going to get out of this one." He just looked confused. I then explained to the judge what happened and that I was obviously not the 67-year-old truck owner who the ticket had been written for. The judge looked at the cop with utter disdain and dismissed it. Story 4. What is the strangest or oddest law that's won a case for you? I won a case where the defendant, New York City, tried to exploit a really stupid law, which I was able to use to win the case. This was a slip and fall case where my client had tripped on a piece of broken sidewalk outside of the Natural History Museum and shattered her arm and wrist. The law is that a property owner is responsible for the sidewalk directly outside of their property, the theory being that even if they can't fix it, they have a duty to warn people about hazards and mark the area off. The museum was owned by the city. There's another concept called sovereign immunity, which is that governments can't be sued without their consent. So the city had passed a very, very stupid law that they would be exempted from the rule that they can't be sued for sidewalk injuries unless you can show they were on notice of hazard, meaning that you would have to show that you informed the Secretary of State, Governor, Mayor, etc., of the exact specific crack in the sidewalk before the injury occurs, and you had to do so in writing with ample time for the city to remedy it 180 days in advance, if I recall correctly. Under normal circumstances, this is impossible. No one anticipates tripping on the sidewalk 180 days in advance, with the foresight to write a letter to the mayor about that specific crack. Luckily, someone did have that foresight, and there was a big nonprofit called Big Apple Maps, which would go around the city with maps of government property and record with insane specificity each and every crack in the sidewalk, pothole, protrusion, and other hazard. And then they would publish these maps while serving copies on the government with the express purpose of combating sovereign immunity defenses and slip and fall cases against the government. I got a hold of one of these maps and visited the site, and I was able to take pictures of the section of the sidewalk where my client fell, and you could clearly see newly placed concrete over the area in the exact position indicated on the map, showing where the sidewalk had been repaired after my client slipped. Basically, the government's attorney brought up the sovereign immunity defense and outlined all of the stupid steps I'd have to go through to overcome their motion to dismiss. My response was, "Oh, you mean this?" and gave them the map. Immediate settlement. Story 5. I had a case where a guy was charged for running a red light. The thing is, he had been sitting at the lights for 5 minutes and it hadn't changed. The wording of the specific section under which he was charged related to stop signs and traffic lights and referred to them as traffic regulation devices. He successfully argued that as the traffic light wasn't changing, it wasn't regulating traffic, and he got off. I couldn't believe it when the judge ruled in my favor. Neither could the police prosecutor. Story 6. Mandatory. I am not a lawyer, but I did beat a traffic ticket based on a poorly worded ordinance and arguing it to the prosecutor. I was charged with approaching a parked public safety vehicle displaying its lights, basically meaning I didn't move over a lane when a police car is on the side of the road. The problem was I was on an on-ramp. There's no lane to move over to. The cop was a jerk and told me I was trying to end him and told me to pay the ticket or go to court and pay more. I read the text of the ordinance he cited me violating and saw the phrase or other prudent action based on road conditions and the driver's judgment. Surprisingly, the key word is and. I just so happen to know that in my state, the word and in legalese can also mean or. This was my very first citation ever with a spotless, decades-long record. I choose to go to court and argue my case. When I arrived, I was put in a pool of people who had tickets to argue and got called up one by one to talk to the public defender. When it was my turn, I said I would like to speak to the city attorney. They were very confused and asked if I was Mr. OP's attorney. I assured them, no, I am OP. I informed the city attorney that the ordinance was written in such a way that handling the situation with the cop on the side of the road was up to my judgment, and I decided that I handled the situation in a safe manner. He looked at the text of the ordinance and then looked at me and had a look of, I can't believe he's right. He dropped the charges. Later that year, the city cleaned up their traffic code and changed the ordinance to make the ordinance end based on a combination of the road conditions, traffic flow, and judgment of similarly skilled motorist, or something like that. Story 7. A family story among some relatives that are lawyers. Not quite an odd law so much as an unwillingness to comply with a rule by the judge. The scenario is this. Two soldiers on a base got into an argument and were struggling over a rifle. The gun went off and one of the two died. The shooter said that he hadn't pulled the trigger, the gun had just gone off. The family of the deceased disagreed. For reasons that have never been clear to me, this case was handled in a non-military court on the condition that two corporals were part of the jury. After everything had been presented, the jury was about to head back to the chambers to deliberate when the prosecution chimed in with one last request. They wanted the judge to prohibit the jurors from reenacting the event with the rifle. There was some back and forth over this, but eventually the judge agreed and asked the jurors to each verbally confirm that they understood they were prohibited from reenacting the scene with the rifle, which everyone, including the corporals, agreed to. The moment the chamber doors were closed, the corporals walked over, took the rifle, and proceeded to tug back and forth with no fingers anywhere near the trigger. Click. They looked at the rest of the jurors and asked, "Do we need to bother with further discussion?" And an hour later, free lunch, if they took long enough, they judged not guilty. The lawyer in question, obviously the defense found out about it. Sometime later, when he ran into one of the corporals in a bar, he laughed and said, "Yeah, when you all went back there, we pretty much were all in agreement that despite the declaration not to, that was obviously what was going to happen." Story 8. The weirdest case I've ever dealt with was Jolie Villa's Pelletier. I did some research for this case when I was a law student. Some background. This was at a time when the Ontario Court of Appeal had held that if there were any factual matters in dispute, a case could not be dismissed on summary judgment. That is not the case today. It was discovered that this position basically ruined summary judgment as a useful process. That was not the case at the time. In such a motion, all facts alleged by the plaintiff would be assumed to be true. What happened was this. A man sued, among others, the College of Dental Surgeons for persecuting him and interfering in his ability to live as a generic Martian. The plaintiff claimed he had been cloned from space debris NASA found in the 60s. He claimed he had a genetic test to prove this, but it had been falsified by the CIA as part of the conspiracy against him. Well, naturally, this claim raised the concern that the plaintiff was bonkers. But there was no evidence aside from his bizarre claims of it. In court, the case was decided on two alternate grounds. First, on the boring grounds that the case was patently frivolous and vexatious because it was absurd. However, it was also decided on the more entertaining basis of standing. Justice Epstein held that only a person could commence an action in Ontario. The rules of civil procedure define a person to be either a human being or a corporation. The plaintiff's whole case was based on him being a Martian. If he was not a Martian, his case had no merit. If he was a Martian, he lacked standing to commence a lawsuit in Ontario. In short, we now have precedent that Martians cannot sue in Ontario. I mean, yeah, fair enough. No winning for Martians, huh? That's pretty messed up, Ontario. Do better. That's not serious, by the way. Story 9. I have one where we won, but didn't quite go as planned. I declined a while ago who was incarcerated at a state prison farm. Inmates had to spend 40, 60 hours a week preparing slop for the hogs from expired restaurant food and cleaning the hog barns. He reeked every time I met with him, even after showering. He said it was miserable. Well, he found out that some Muslim inmates who couldn't work with pigs were offered to be able to work at the police horse stables instead 5 minutes down the road. He wanted to sue, saying that stable work is much less revolting than hog work, and that this amounted to unequal punishment on the basis of religion. I thought he had a point. Well, the case didn't get thrown out and actually got some traction. But then the prison changed their policies in response. Inmates who couldn't work around pigs or didn't want to would instead be transported to a factory chicken barn the next county over for work each day. He asked that I drop the lawsuit, and the Muslim inmates were not happy with him. Story 10. Over 10 years ago, I'd been at fault for rear-ending someone. I had no insurance, and my license had expired. I don't think I need to mention I was in a very destitute, low place in life, struggling with almost every conceivable aspect of living. The cop was very kind as we talked, but wrote me a ticket for it all. One was kind of a fix-it ticket about my suspended license. I sorted that out in the days after, and nothing came of it. The cop had mentioned that he had to write the insurance ticket, but to take it to court and get it lowered. I was desperate to try to get my $800 insurance ticket lowered because I couldn't afford something like that. So I took the cop's advice. I went into traffic court weeks later, and when it was my time to chat with the judge in front of everyone there, the judge looked at the ticket, stopped me, and said, "I would like to use Mr. OP's case as an example to the gallery." I almost died. He went on, "This is a court of law, but it is also a court of fairness. It seems as if the officer didn't write the date of the incident on the ticket. I can't hold OP accountable to this." My jaw dropped. I stood there. The judge told me I was free to go twice before it registered. I'm pretty sure that cop deliberately didn't write the date on the ticket. Thanks, officer. Story 11. There was a case here in Hawaii that got thrown out like this. Someone got pulled over because the police saw she had way too many passengers in the car. Then they noticed she was drunk. Open and shut case. Well, apparently in Hawaii, there's no law defining the maximum number of passengers in a private vehicle. So the issue was that all the extra passengers weren't wearing seatbelts. Well, this failed too, because the law only says that every available seatbelt needs to be in use. Well, if you have 6 passengers and only 5 seatbelts, well, there's nothing at all illegal about it. So since there was no probable cause to pull her over in the first place, even though she was indefensibly drunk, the whole thing got thrown out. Hawaii has some very counterintuitive laws. If your truck has seats installed in the bed, your passengers must be buckled up. If not, they can just party back there, while anyone in the cab unbuckled would get you a major ticket. People regularly ride down the freeway in truck beds while sitting in lawn chairs. Just from like a public safety perspective, horrifying laws. Those kinds of loopholes, in my opinion, just straight up dangerous. So, don't love it, but interesting. Story 12. I got a pro bono client's removal by USCIS canceled. He had a low-level drug possession conviction from the early 80s. During that brief period, the active ingredient of Imodium was illegal under state law, but not federal law. So I successfully argued that they couldn't prove it wasn't a conviction for possession of a substance that was federally legal at the time, and as such was not subject to removal. The argument worked, and my guy went back to his business and his family. Story 13. Had a guy in USAF basic training that should have been a lawyer. When pulling dorm guard duty, we were supposed to ask anyone requesting entry to show their military ID through the window in the door and then compare the names shown to an approved entry list. Failure to confirm ID before allowing entry was a security infraction. So this one dude is dorm guard when a TI training instructor is going around from dorm to dorm, making sure the airmen on duty are following procedures. The TI knocks on the door and demands entry. For whatever reason, the airman lets the TI in without asking to see ID. The TI blows a gasket, starts screaming at the airman about how much trouble he's going to be in when the TI reports what happened. He demands the airman hand over a Form 341, which is used to document rules infractions. Sir, I'll give you a 341, but I think you should know this door's broken. What the hell are you talking about, airman? Sir, we found if you kick the door on the bottom left corner, it opens whether it's locked or not. Show me what you're talking about. The two step out into the hallway, and the airman shows the TI where to kick the door. Sir, let me step back inside and lock the door so you can try it yourself. The airman steps back inside, then locks it. The TI tries kicking the door, but it remains locked. Airman, I thought you said this door is broken. It worked the last time I tried it. Well, it looks like it's working fine now. Open up and give me a 341. Sir, if you're requesting entry to the dorm, I'll have to see your ID first. I feel like we were left out of the most important part. Did he get away with it? Because my God, if he did, he is a wizard. This sounds like something that he would not get away with if I had to guess. At the very least, though, I'm sure at least one of them had a good laugh. Story 14. A guy got drunk and decided to ride his horse through town. This was a small town in North Carolina. Well, he would stop at each intersection and fire his pistol in the air like some Wild West cowboy. Anyway, the guy was charged with a DUI and discharge of a firearm within city limits, which was a felony. So as one would soon find, it's not just mandatory but a law that you must fire your firearm into the air at an intersection when coming through town on your horse. An old blue law that never got erased. He still got the DUI and his horse impounded, but the dumbfound judge dropped the other charges. Story 15. Had a case where my opponent filed an appeal from an administrative agency to the local circuit court. The requirements for filing the appeal are very strict, and the filing must include an appeal bond executed by the individual defendant or corporate officer. When my opponent's assistant electronically filed the appeal, she attached a PDF of the bond without the corporate signature. There's no question in my mind they had the bond with the requisite signature and simply attached the wrong version of the document to the filing. Wish I could say there was a huge court fight over this and I got to slam my opponent, but that's not how this works among professionals. I waited until after the time to correct this error had passed. I then politely called my opponent, told him that I was holding the I win button and that I would be filing a motion to that effect in a week. My opponent came to me with very favorable settlement terms within days. To this day, I don't know for sure if my opponent ever disclosed his mistake to his client, but I doubt it. Story 16. Had a client who was a truck driver. He got various penal infractions for issues with his truck. Several $1,000s in fines, basically. Anyway, the evidence is pretty damning. Lots of pictures showing defects, detailed description by the traffic control officer, and so on. However, to find him guilty, the prosecutor technically has to prove that the vehicle he was driving is considered a heavy vehicle. The law says this: heavy vehicle means a road vehicle or combination of road vehicles within the meaning of the Highway Safety Code, having a gross vehicle weight rating or gross combination weight rating of 4,500 kilograms or more. B, a bus, minibus, or tow truck within the meaning of that code. C, a road vehicle subject to a regulation made under Section 622 of that code. The traffic control officer had not listed the weight of the vehicle in his report. There's pictures of it, clearly an 18-wheel truck, but no weight written anywhere. So I told the judge that the prosecution hadn't proven the weight of the vehicle per the definition of heavy vehicle. The pictures don't prove the numerical weight, just the shape of the vehicle. She had no choice but to acquit him because all the infractions he had received were for a heavy vehicle operator. And so he can't be guilty if they can't prove he was operating a heavy vehicle. Story 17. I once had a client who woke up in the middle of the night to the sound of someone in his home. He retrieved a Colt 1911 from a bedside drawer, walked into his living room, and confronted a figure in the dark. The person didn't identify himself, but moved toward my client, who fired a single shot that went through the person's shoulder. Turned out it was my client's stepson who had snuck out, been drinking underage, and stumbled home. The problem with the situation was that my client was a convicted felon. That meant that while the shooting itself was legally defensible, his possession of the firearm wasn't. We looked into the history of the gun itself, as our client had indicated it had belonged to his grandfather, who had served in the U.S. Army in the early 20th century. Ultimately, we were able to bring multiple experts in and establish that the gun had been among the very first batch of firearms distributed from Colt to the U.S. Army at the Augusta Armory. Florida Statute 790-101 creates an exemption of firearm-related laws, including the prohibition for felons to possess a firearm if the firearm in question is an antique, meaning it was manufactured prior to 1918. Since we could establish the history of the firearm to have been manufactured before 1918, our client couldn't be prosecuted for the offense and got out from underneath a potentially mandatory prison sentence. Story 18. I'd one where a client was contesting a will. Halfway through the case, the other side argued that my client was set to inherit less without the will if we won than she would with it if we lost, and argued she lacked standing to attack the will. The decedent had a very old will that benefited our client's deceased mother, but that will had been revoked. We found a very old doctrine in a footnote to something else entirely, and argued to the judge that the law assumes you'd rather die with an old revoked will than with none at all. Therefore, we argued he should look back to the prior will. Since our client would inherit her mother's bequest under the prior will, he held our client had a standing to bring the will contest. We ended up settling the case shortly thereafter. Story 19. I'm not a lawyer, and the story isn't great, but it's mine. I look back on it and think that telling the truth seems like an odd way to win a case. Cop said he got me to an over 85 and a 65 based on a visual approximation on about a 1-2% incline. Put 73 on the ticket just to give me a break. My old frickin' car couldn't go past 83. I went to the track once just to find out and had a little slip to prove it, though that was hardly evidence. Prosecuting attorney asked me who I was then. Well, what's your defense? I told her it seemed like a bad idea to talk to her about anything and that I wouldn't be doing that. She added enough nonsense I would have lost my license. Opened by discussing that fact with the addition of the charges, noted prosecution's behavior was malicious and vindictive. Got told I couldn't say stuff like that, but she affirmed the exchange happened. A bunch of charges like driving without a seatbelt, reckless endangerment, operation a higher speed charge, and eluding the police. He lit me up on a bridge. I put my flashes on, then pulled over slightly after the bridge because it wasn't safe. Started by asking the officer to describe the day. Sunny, dry, minimal traffic. Straight, smooth, flat, well-kept road. Given the road conditions, the officer agreed that my vehicle was well under control and did not merit the conditions for reckless. He stated that with his vehicle and training, he would have no issue safely exceeding 100 mph under those circumstances. Kept talking to the cop. He said I had my seatbelt on, said I was polite, and I asked him if he felt that my delaying the stop was for his safety or to hide or destroy evidence. He noted my car was spotless, and I explained my reasoning for pulling over late, offering to let him search it if he was so inclined. He declined. A 95 Jeep Cherokee, so no trunk and big windows, offered to let him search my backpack. He declined. He said I was doing 85, gave me a break for the speed. I asked him again if I was doing the speed on the ticket, and he said no. He asked me if I knew how fast I was going. I said not exactly, but I didn't think I was speeding, because I always double-check my speed in that area where they sit, and my vehicle probably couldn't do 80 going up any kind of incline. As I brought stuff up that made her look stupid, he kept this huge grin. I asked for everything to be dropped because based on the citation and testimony, the ticket was incorrect, and the rest was just spite trying to punish me for wanting to experience the judicial process. I asked the judge if the sort of behavior from a prosecutor was the type that should be reported. He was non-committal, but urged me to report it if I believed as much. I reported her, and nothing came of it that I knew of. He dismissed the ticket. Talking to the cop on the way out, he said something like, "Okay, but you know you were speeding." We laughed, and I told him, "No idea. But hey, innocent until proven guilty or something." Really pleasant and solid guy all over. He let me pet his dog. I probably was speeding, but I really couldn't be doing the speed he stated, and definitely wasn't doing the one he wrote. So meh. Next car had cruise control. Story 20. Once won a case that forbade the possession or transport of human urine in order to adulterate a urine screen. It wasn't human urine. It was fake lab-made urine from a website. Edit. Realizing I kind of messed up with the phrasing here, I had a client who was caught with a little container of alleged urine that he may or may not have been about to use to mess up a drug screen. Since he hadn't messed with a drug screen or actually tried to mess with one, yet he couldn't be charged for that, so he was charged with trying to transport human urine with the intent to adulterate a urine screen. Meaning I got to argue that one, the prosecution hadn't proven it was human urine, they didn't test it. Two, they deprived us of the opportunity to test it because the officer poured it out before giving the container back to the client. Three, my client could literally testify it wasn't human urine. He's still known around the office as Human Urine Guy. We have a lot of nicknames like that around here. Human Urine Guy Drywall, Guy Donkey Kick, Guy Fire Truck, Guy Backpack, Girl Cornhole, Board Guy. Bonus. The prosecutor got offended because I made a motion to suppress the search of my client based on a violation of the Fourth Amendment. Prosecutor thought we'd agreed that the search was good. The search was good based on the facts in the police report. Not my fault that the police officer testified like an idiot once he got on the stand. Story 21. I once got out of a parking ticket by refusing to admit I was the driver. In the UK, parking companies that use automatic plate number recognition can get the contact details of the registered keeper of a car from the DVLA or DMV, and they send them the fine in the post. But I did some Googling and found out that illegally it's not the registered keeper who is liable for the fine, it's whoever was driving at the time. This isn't always the case. There are situations where they can hold the keeper liable, but in my specific case, it didn't apply. They really don't like you knowing this. Their letters are worded very carefully to give you the impression that you're liable for the fine as the keeper of the vehicle without ever actually outright saying that. And they do the crap where you can pay either a reduced fine now or appeal and pay a bigger fine later. I appealed. I didn't lie and claim I wasn't the driver. Instead, I just pointed out that they're contacting me as the registered keeper and that the registered keeper isn't legally liable to pay the fine and that I'm under no obligation to give them any details of who was driving at the time. It took 2 months and 2 appeals, but eventually I won. I didn't have to pay the $20 fine. I would have paid, but I felt like I really hadn't done anything wrong. I didn't park illegally or over time or not paid or anything. I had just forgotten to validate my parking after shopping at Tesco. Story 22. I'm not a lawyer, but I got my case for reckless operation of a vehicle thrown out, turned out, dropped, forgotten about. I don't know what to call it. I was younger and was one of those kids with a loud muffler driving all over the place. Eventually it caught up with me. I got 3 major speeding tickets, 30 plus miles per hour over the limit, all within 30 days, which is an automatic summons for reckless operation. I arrived at court and waited as they called people up and handed out punishments. After hours, everyone had left, and the state officer walked up to me and asked why I was here. I presented my summons slip, and he had no record of it. He went to the office, and it wasn't even in the computer. They gave me a new one and told me to come back in 90 days. Lo and behold, in 90 days, for some reason, it still wasn't in the computer. It was as if I was never pulled over at all that final third time. The officer must have slipped up and forgot to submit some kind of paperwork. They tried to give me another one, but I put up a stink saying I'd held up my legal obligation not once but twice, and I was going to get a lawyer involved. They slapped me with a $100 fine and sent me on my way without any further repercussions. Biggest bullet I've ever dodged thus far. I likely would have lost my license for some amount of time. Chances are, with a lawyer, I wouldn't have even been fined, but that was too much hassle. Besides, I had broken the law. I deserved a fine at the very least. Story 23. Not a lawyer, but I did enough law research to get myself out of a parking ticket one time. When I was in college, I was in the marching band. We had a storage room in the basement of one of the dorms. I was going to get something out of the storage room and parked in the loading dock behind the dorm. There was just enough room next to a dumpster to fit my car. I didn't want to spend $5 on a loading zone pass from parking services because I was a broke college student. So I just parked. I was only going to be 2 minutes anyway. I finished picking up what I need to, and sure enough, I come back out to my car to a parking ticket. Except it isn't the $25 ticket for parking in a loading zone. No. It's $75 for parking in a fire lane. There was a single sign at the very front of the side road leading up to the loading zone, but no curb paint, no indication of where the fire lane started and where it stopped. I called parking enforcement telling them this, and they wouldn't budge. Fine. I took pictures of the loading dock and I submitted an information request to obtain the evidence pictures. I got the pictures and started researching fire lane requirements in the state. What I found clearly indicated that curb stripes were mandatory. I called parking enforcement and told them what I found, and they still wouldn't budge. Frustratingly, I looked at the law again. The part they cited me for said that nothing could obstruct a fire lane at any time. I looked back at the evidence photos and saw the dumpster next to my car. Hey, if this was a fire lane, the dumpster was blocking it too. The same state law they cited me with said that non-vehicle obstruction of a fire lane was subject to a fine of $1,500 a day. I found satellite imagery from 4 years prior showing that the dumpster had been there for at least 4 years. So I argued to university parking enforcement that if this was a fire lane, then the university had been obstructing it for at least 4 years and would owe the state $2.2 million in fines if I reported it. The parking ticket disappeared immediately when I sent the appeals committee their own evidence photos, satellite imagery, and the same state law they cited me with. I drove by a week later and the dumpster was gone, the curb painted, and 2 brand new fire lane signs were put up. Story 24. I am not a lawyer, but when I was in high school, my friends and I used to flower bomb cars. Now this is stupid. You should not do this. I was caught by police and given a fine of $360, the maximum allowed with what I was being charged with. I contested it because I was broke and figured the officer wouldn't show up to traffic court. The language of this law was oddly specific. I was charged with throwing or placing a dangerous or injurious object in a roadway. If the language had been left at this, it would have been pretty easy for them to enforce it, and I would have no choice but to pay. I also want to be clear that I definitely did something stupid, and I could have hurt someone. I deserved whatever was coming. But the law went on to define with strange specificity what constituted a dangerous or injurious object. It included things like rocks, pine cones, plates, tires, and on and on and on. But nowhere did it say anything about flour or food or paper towels or rubber bands. The room was divided into normal traffic violations like speeding and whatnot, and then the other. Myself and one other person were the others, and we got to go first. I had no idea what I was doing. But when it was my turn, I got up in front of the court, pulled out a law book and read this, and then presented a flower bomb I made and made a nervous attempt to explain why I didn't think it met their definition. The DA and the police officer who gave me the ticket had an exchange and then spoke with the judge for a minute. They didn't look all that concerned nor pleased, but after a minute or so, the judge just said I was free to go, and the fine was dismissed. A few people started laughing and a bunch of people clapped, which I must admit felt kind of awesome. Again, a dumb thing to do, and not exactly in the spirit of the law. But hey, I was a turd and got away with it. Story 25. I have a story from Australia, but I am not a lawyer. I received a letter from the SDRO State Debt Recovery Organization stating that I had unpaid debts. They gave me 30 days to pay them, otherwise they would be arriving at my home to repossess everything I own. This included furniture. Furniture was specifically mentioned in the notice. This really ticked me off. I've never had unpaid debts. In addition, I lived in an apartment with my brothers. Who were these clowns to threaten that they would take all my furniture and belongings with 30 days notice? When I checked the details of the notice, it was for unpaid traffic fines from more than a decade ago. The most recent notice was from 13 years ago, the oldest 15. With interest and other penalties, they wanted a couple of $1,000, big money to me at the time, 20 years ago. Now, when I was in my early 20s, I did have a motorbike, and I did rack up a few speeding fines, but hey, I paid them. Back then, you had to pay them because if you didn't, your license got canceled. My license had never been canceled. I paid the fines by money order. After about 5 years, I got a new wallet, looked at these stubs for the money. Orders laughed at myself for being paranoid and threw them out with my old wallet. Surely no one would want them by now. And a few years later, well, these notices arrived. I called SDRO to say these charges were invalid. They'd been paid years ago. They said, no problem. We just need a letter from the issuing authority to say so. I checked, and the issuing authority no longer existed. It had been closed down years ago, and a new government authority, the RTA, now existed. I called the SDRO back and they said, sorry, but unless the relevant authority says the debt has been paid, we can't cancel. But the relevant authority no longer existed. This seemed Kafkaesque to me. I then called the Sydney Central Court. One of the clerks there took pity on me and gave me a huge tip. When they shut down the old government authority and started up the new one, they of course had to transfer records from the old one to the new one. She thought my payments might have been made at the time of the transfer and somehow not been recorded on the old system or the new one. My first clue. I contacted the SDRO again and told them I believed these debts had been paid and had been accidentally resurrected in the course of switching systems. This time, one of their lawyers wrote to me and said I had not proved this was the case. Well, true, and that the debts still stood. Here is where I had my moment of genius. I told them the debts were paid, and because 7 years had expired, I no longer had to provide proof that I had done it. In the next letter, he told me, because the debts were for traffic offenses, they became a criminal matter and did not expire after 7 years and still stood. My next letter, I told them it only became a criminal matter if they were unpaid. However, I said they had been paid, therefore no longer a criminal matter. Therefore, I no longer had to supply proof they had been paid. His next letter, oh, you have to prove they've been paid. Until then, it remains a criminal matter. My next letter, as you are claiming a debt against me, I don't have to prove they're paid. Instead, it's up to you to prove they're unpaid. In fact, because the debts you were asserting are so old, there has been a denial of natural justice. The law says I don't have to retain receipts for more than 7 years, but by trying to collect on a debt so old, you're trying to force me to supply proof that according to the law I no longer need to have. From there, I escalated things to the ombudsman, and I won. Or the ombudsman did. The debts were canceled or assumed to be paid off. I'm glad I won in the end, but can you imagine receiving claims for debts more than a decade old? How ridiculous and unfair. Now, 30 years later, we have robo-debt in Australia, and I suspect it is illegal to try to force people to prove things about their income from more than 7 years ago. Story 26. Prior to becoming an attorney, I worked retail for a few months. The way my assistant manager scheduled me, I had to work 10 days straight, including a couple of 12-hour shifts with no days off and minimal overtime. The way they got around the overtime was by scheduling me the last 5 days of one week and the first 5 days of the second week. So I only worked 40 hours in the work week, plus the 4 hours of overtime for the 12-hour shift. That didn't seem right to me, so I looked up the law in Virginia. While they could technically do that, there was an archaic law at the time in Virginia that stated if a non-essential or non-managerial worker wanted Sundays off, the job had to give the Sundays off without penalty. This was true even if the worker agreed in accepting the job to work on Sundays. The worker under the law could change his or her mind and ask for all Sundays off. As the worker was not essential or a manager, then the employer had to accommodate. I took the law to my manager and said that I was not going to work Sundays anymore. He said that they wouldn't schedule me that many days in a row anymore, but I still had to work Sundays. I told him that I did not and gave him the statute. It caused a big stink, and I ultimately found a better job not long after. But I never worked a Sunday there again. Ironically, a few years later, the Virginia General Assembly accidentally created a law that nullified the essential worker and manager bit of the Sunday law. That made the news, and suddenly people were aware of this archaic law that they could ask for Sundays off. I remember the news saying that no one knew about this law because I thought to myself, hey, I did. The General Assembly repealed the entire law about Sundays, so now workers do have to work Sundays. That was the only time, though, that I found an archaic law to help me out. Story 27. I had a client with a serious medical problem that cost her her job, and she was preparing to file bankruptcy on the medical bills and credit card debts. Thing was, she had like $15,000 socked away and didn't tell me. It was all that was left of her life savings. Before we filed her case, she gave it to her mom for safekeeping. What she didn't know is that she could have kept the money through the bankruptcy, but giving it away beforehand is a no-no. I had to tell the court when I found out, and when this happens, the court gets the right to sue the mom for the $15,000. The thing is, the mom's debt to her daughter's bankruptcy court also dischargeable in bankruptcy. So the mom filed bankruptcy too, and they got to keep the money after all. Story 28. Not a lawyer, but we were talking about NCAA rules for cross-country running once, and we focused in on the rule that said the runner needed to have at least one shoe on when crossing the finish line. Apparently, the rule's been changed now because 2021 rules say barefoot is okay. A few weeks later, I was running in a separate race and had a bit of debris in my shoe that was causing immense pain. So I ripped the one shoe off and kept running with one shoe on, knowing that I needed to cross the finish line with one shoe. I didn't win, but I got one of my best times and beat our best runner. Running can be a psychological thing, and running half barefoot somehow motivated me and demoralized him at the same time while I passed him carrying one of my shoes. Story 29. Obligatory, I am not a lawyer. My mom was getting sued by a debt collection company that was well known for suing people as a means of threatening them. I had some time, and I looked up the laws on debt collection. Where we lived at the time, you had the right to demand in writing that they provide evidence that they actually hold the debt, and they had a certain amount of time to respond under the law, where they forfeit any right to collect said debt. I sent them a certified letter. We never heard back. When we went to court, I submitted the receipt for the certified letter and said they'd failed to provide proof within the legal time frame and cited the law. Case dismissed with prejudice. The lawyer for their side didn't even care. Story 30. I wasn't the lawyer but a bailiff at the time. This wasn't strange so much as funny in a way. So an officer pulled over a man for obviously driving while intoxicated, or so it seemed, swerving a bit slower than expected for flow of traffic, which yes, that can get you a ticket, and blowing through a stop sign. Soon as the officer pulled the guy over, the man stepped out of the vehicle and took a huge swig from a bottle of whiskey. Officer arrested him with a DUI, and dude did blow well over the legal limit. Fast forward to the trial. The guy's lawyer argued that while his client may have been impaired to driving, the fact remains that since he drank a big swig of alcohol, as soon as he was stopped and stepped out of the vehicle, the officer couldn't be certain if that was what pushed him over the legal limit or not. The lawyer countered that the officer couldn't have then reasonably charged him with a DUI, as it was entirely possible he was fine before that big last gulp. Long story short, the judge agreed and had to throw out the DUI charge, though he didn't want to, as he reasoned that while the defendant's reasoning was sound in the law, by the same token he feared it might encourage abuse. Whatever the case, the guy got off on the DUI charge. I later heard this may not have been the first time the guy has tried this stunt. Story 31. Contrary to popular perception, the legal system does not involve a hunt for some arcane law that lets you win with this one simple trick. The closest I've ever come to that, and it was a complete aberration, was a complex dispute over the validity of a mortgage note with a bank. One of the issues was whether there was sufficient consideration, something of value exchanged for the note. And sure as hell, the contract had seal written after each of the signatures, so that resolved that particular issue, but then there were a whole bunch of other allegations of fraud and self-dealing to sort out. 90% of legal cases involve credibility disputes between witnesses about what happened, not finding some magical Harry Potter-type Latin spell to utter in court. Story 32. Happened to me when I was a teenager. My friends and I bought some beer and then went to a high school football game the first week of my senior year. We obviously got caught, and all 6 of us got tickets for underage possession of alcohol. I was the designated driver and had been driving my dad's Suburban with our very unique last name on the license plate. So it was really easy to figure out whose car it was. Went to court a few months later. The ADA presents her case. Cops testify. They even brought the alcohol in as evidence. Right after she rested her case, my attorney steps up and asks the judge to dismiss the case. We are all very confused. The judge looks at the ADA and just kind of shakes her head and agrees. My attorney explained later that she forgot to prove we were under 21, so there wasn't a case anymore. I've never been so glad for technicality in my life. Story 32. I am not a lawyer. We purchased a motorcycle at the beginning-ish of the year. DMVs are horribly backed up, and we got an appointment as soon as we possibly could to get plates and registration. Day of the appointment, we were very excited to finally have everything legally registered. We go get a VIN verification, which didn't take long, and so we thought, let's go grab some lunch. We parked and paid for parking, then came back to a ticket for no plates on the vehicle. The officer wrote the ticket for a city ordinance that states it is illegal to drive, park, etc. Any vehicle that has been assigned a license plate or plates without having plate attached to said vehicle. Great news, though. I haven't been assigned a license plate. Ticket dropped. Story 33. Early in my career, I had a fairly minor case in which my client's neighbor cut down a bunch of shrubs and small trees bordering their properties because they blocked his view. This really irritated my client as he wanted his privacy. Now, the monetary damages were actually not that much, and this was looking like a case that really couldn't be economically litigated for what the client could afford. However, in researching the issue, I found a rather obscure law that provides for attorney's fees to a winning plaintiff when a defendant has willfully damaged the border foliage of a ranch or farm. In looking up the definition of these terms, I realized my client's property actually qualified for the statute as he used his land for growing a variety of produce for market. Once attorney's fees were on the table, the other side quickly caved and wrote a big check to cover the damages. Story 34. My buddy got out of a DUI because of his hot girlfriend. His lawyer went with the improper procedures route. My buddy refused to blow on site, requesting to blow at the police station. They had to do 3 consecutive tests, and he was allowed a witness to attend the tests. He called his girlfriend, and she wasn't able to make it for the first test, but they let her in for the following 2. One of the rules is that the officer performing the test must keep his eyes on the accused throughout all 3 to ensure nothing fishy happened. His lawyer called his smoke show girlfriend to the stand and argued that the officer performing the test had to have taken his eyes off my buddy to look at her. They won. Story 33. I had my personal truck towed from a Walmart parking lot for being illegally parked. Well, this ticked me off, so I decided to look up and read all the parking towing laws in Ohio. After reading said laws, I called the towing company that was responsible for what I assumed to be an improper tow and informed them of their mistakes. 1, there weren't signs stating the proper information like no parking, name of towing company, etc. at all entrances to the parking lot. I went back and checked. The entrance I used didn't have a sign. I also made sure to take a video and pics. 2, I contacted the local sheriff's office and some other office, forget their name, and both said that the towing of my truck was never reported. There's a specific law that says if you tow a vehicle, you have to take pictures and make the local authorities aware of the incident within a certain amount of time, like 24 hours or something. 3, the location of their lot where they towed my vehicle to was further than 30 miles away from the Walmart. It's a law that it is within 30 miles. They were like 31 or 32 away. So after explaining this to them pretty damn well, and after receiving a lot of negative comments about how they've never dealt with anyone like me before, how much of a jerk I am, I should just pay the $150 I threatened them with litigation. I said I could take this to a small claims court and sue them for 3 times the amount I would have lost, and the poor dude who towed my truck would get slapped with a misdemeanor. Needless to say, they caved and told me I can just pick it up whenever. They put up a sign at the entrance I used within a week and probably started following the laws after that. Story 34. Virginia divorce. Female spouse was cheating on well-off male spouse. Man found out, started divorce proceedings, and woman found out she would get no spousal support. She did, however, find out about a concept called condonation, which means if you sleep with someone after knowing they've committed adultery, you've forgiven them and can get spousal support. Well, one night of text messages and a few photos confirmed it, and client received a lucrative spousal settlement based on the new information. Story 35. Not my case, but a case my office handled. In Belgium, a break-in during the night is punished more severely than a break-in during the day. The question then is, well, when does the night start? The night legally starts at sundown and ends when the sun comes up. This was before the internet was mainstream, and basically every household had the same calendar. You could pull the day of, and there would be some information on the day, month, the moon and the sun, the patron saint of the day, and maybe a joke. Like this calendar was known by everyone as the standard calendar. The prosecutor used the date on the calendar to state the sun went down on the day of the break-in at 9:36 or something like that. So since the break-in was caught by the police at 9:38, the more severe punishment was in order. My office found it really stupid the guy had a more severe punishment for 2 minutes. So they started looking and came upon the Belgium Royal Stargazing Observatory, where the legal association to record weather and things like that. So we wrote them a letter asking what time the sun went down that day, And lo and behold, the certificate from the Royal Observatory stated the sun went down at 9:39 that day. Client got the lighter punishment for a regular break-in, not the break-in at night. That kind of distinction is just asking for this, though. Like, what a stupid, arbitrary sort of thing. I don't know what punishment this person deserved. I don't know why they did the break-in or anything like that. All I know is this law is stupid as hell. Story 36. I'm not a lawyer, but I once got out of a speeding ticket going over 100 miles per hour. I was pulled over by the sheriff and ticketed. Luckily, he let me go and didn't arrest me. I was given my court date and went to my arraignment and pled not guilty, and they set another court date for me to plead my case. Then I made discovery requests on everything I could think of. Officers' notes his whereabouts for the entire day, the service records of his vehicle, etc. This was quite a hassle because I had to write the request and send it to like 3 different places. The sheriff, the court, and some records place or something. Well, of course they didn't comply and sent me nothing, so I went to my court date, told the judge I can't possibly defend myself because my discovery request wasn't complied with, as is my right, and requested the court order compliance and a new court date set. Well, the judge obviously didn't like this, but he had no choice but to demand the sheriff's department to comply and send me the information I requested in discovery. So he set another court date, which I knew was outside of my speedy trial rights date. I told the judge I do not waive my right to a speedy trial and demanded an earlier court date. This really ticked him off. He couldn't offer me an earlier date because the courts were overloaded and jammed up with other cases. He basically told me to screw off and they'll see me at my next court date. So the sheriff ended up complying with the court order and sent me a packet of information. Finally, my next court date rolls around and I see another judge. I made a motion to dismiss on the grounds that my speedy trial rights had been violated, and I didn't waive them as so many people do. The judge had no choice but to dismiss all charges, but not before lecturing me about the dangers of speeding. Story 37. Not a lawyer, but this happened to me in college about 6 years ago. I was working 2 jobs and attending community college and still barely making ends meet. My best friend was accepted into a university about an hour away and needed a ride. At the time, my cousin, who was deployed for a few years, let me borrow her car for a while. So fast forward to us getting there. It's her first day of class and she's close to being late. I hurry to back out and I back right into a parked car. She gets out to check and it isn't that bad, so we drive away. A week later, campus police calls her in and I turn myself in. Cop was super nice and told me that watching the ordeal on camera was hilarious. Lo and behold, I hit the dean of residence's car, and the cop made a deal with me that if I paid the dean for the damages, I wouldn't have any trouble in court. After all, I was looking to hit and run. Fast forward to court, and the cop doesn't show up. Judge says the no-show means my case had to be thrown out completely. I still paid the guy afterwards after guilt. For 2 months, I had not a dime in order to pay. I even gave blood just to have enough money for gas to get back home after paying him. Looking back on it legally, I didn't have to pay him. And I may have paid him in smaller increments if I knew that then. Story 38. In Florida, we used a really old writ from English common law called the writ of error coram nobis to overturn old convictions that couldn't otherwise be attacked. That's a simplistic explanation. It's actually more complicated than that. But anyway, these writs originated in England in the 1500s, came to the U.S. with English common law, and remained the law after the Revolution. In some states, you can still use them. An enterprising lawyer I knew, who was also a medieval legal scholar, figured this out, and we started filing these motions based on the writ. Surprisingly, judges started granting them. It mostly came up in situations where the state was trying to enhance a current charge or sentence based on a prior conviction. We would use the writ to attack the prior convictions and eliminate the enhancement. It worked for a while. Then the Florida Supreme Court decided it had enough and eliminated the ability to use coram nobis by declaring it had been subsumed into a subsequent statute. It was fun while it lasted, though. Story 39. Mine is more funny in my opinion than strange. I was recently in legal trouble, charged with F1 aggravated burglary. My ex-roommate stole my cat twice. The second time, I waited with a friend who lived across from her and watched her leave her apartment and not lock the door, so I walked in and got my cat. I couldn't get out of the building's halls before she got back and she attacked me. One of the girls across the hall came out and maced my ex-roommate, and the police were called. Anyway, I ended up in county and my ILs pay my bail roughly 36 hours later. Go through all the court stuff and it's bound over to grand jury. They took a day looking at it and dropped the case. My lawyer said they didn't want to waste time pursuing something so stupid. Still don't have my cat, and the charge will stay on my record for 2 years. It's the one and only time I've been in trouble with the law. Not counting some mandatory one-time counseling for staying out past curfew at 14. Story 40. I'm not a lawyer, and this is a super-duper sucky thing that happened. But happen it did. POS murders, someone gets arrested and charged then released on bail for reasons. Over the next 14 months, POS attends directional hearings and all other court dates in the lead-up to the murder trial. 1 month prior to the trial, POS is out driving, causes an accident resulting in one person severely injured and another losing their life. Bail is not revoked, and POS stays on bail for murder after murdering another person until the trial. Why was he allowed to stay out on bail? Well, 2 reasons. A, he hadn't broken any of his bail conditions, meaning there was nothing in his conditions saying he wasn't allowed to cause the death of another person whilst on bail for murdering the first. B, if his bail were revoked a mere 30 days before the murder trial, the jury would need to be told why, and this would mean they would be less likely to have an objective and neutral leaning. He was found guilty of murder, and whilst incarcerated, had to stand trial for the second incident of driving in a dangerous manner, causing death, which he was also found guilty of. 21 years later, he is now paroled after serving a total of 17 years for the murder and 11 months for the driving. We created a petition to get the law changed that someone who is charged with murder shouldn't be allowed bail, or at least if they take another person's life, they should immediately have bail revoked. But sadly, we were unsuccessful. Story 41. Not a lawyer, but my dad got out of a speeding ticket due to being able to prove that the police officer had lied about the interaction they had. He was in a very distinctive bright green sports car and was followed by a marked car for about 10 minutes without committing an infraction. After he pulled into his own driveway, the cop came over and told him he was speeding and driving dangerously. The officer had an attractive young female officer in his car that didn't get out and watch from her seat. He spoke to the officer, and a bit of petty argument happened through a 1-inch crack in the window because the window motor was broken and the parts ordered had not been in stock at the dealership due to rarity. In court, the older male officer gives his version of events, saying Dad has been rude, abusive, threatening, etc., doing twice the speed limit in his own street, supposedly. The female officer then took the stand and repeated word for word what her male counterpart had said. She was asked where she was and how she could hear all this. She says she was in the marked car passenger seat at the time and heard it because Dad had his window down. Dad was able to produce the order for the power window motor from the dealership, the invoice for the installation of the replacement after the ticket, and a statement from the dealership that it was stuck in the nearly up position with a small crack at the top. Judge was already very skeptical of how perfectly the female officer's story matched her superior's, in spite of being in another car a short distance away, and the evidence that the window was barely open got it thrown out. Story 42. 2 years ago, my partner was pregnant and had a medical episode behind the wheel of the car while driving. Long story short, the baby caused her to momentarily lose consciousness by stopping blood flow. She had issues with fainting through her pregnancy from that point on. The issue at that point was it happened as she turned a corner, straight after a set of traffic lights. Normally, this wouldn't have been an issue except for the person who decided to stop immediately in front of her to turn across the opposite lane into a service gas station. Needless to say, she rear-ended the guy. Police and ambulances were called as she had to go to the hospital. Cops on the scene said everything was cool and no one was going to be charged for anything. Fast forward a month and she gets a ticket for failing to maintain a safe distance, which has been issued by the headquarters on automatic review, revenue-raising attempt. We managed to get the prosecution to drop the charge by successfully arguing that she had a medical episode because there currently is no case law saying a medical episode is a valid reason to break the law, and the police didn't want one. In the end, it cost us over $1,000 in legal fees, and the ticket was only worth $200. But she managed to keep her license. Story 43. Not a legal law, but a law of physics. I was acting in a financially substantial case in which movement of an extremely heavy, expensive thing was an issue. An opposing party plaintiff appointed an expert who calculated the energy of the moving thing using an incorrect formula. Goodness knows what he was thinking. He didn't mistakenly use the wrong formula. The formula he used was gibberish. And it wasn't just a typo, it was several characters wrong compared to the correct formula. Anyway, as it happens, I did quite well in math in high school, and I picked up on the error. I contacted the lawyers acting for the other two defendants and pointed out the error. And we agreed none of us would say a word until the right moment. We got 3 different high school textbooks showing the correct formula. This guy gets in the witness box, and in cross, we build him up to agree that his energy calculation is completely critical to his whole analysis. Then bam, we hit him with the first textbook. He denies he's wrong and says the textbook must have an error in it. We hit him with the second textbook. He goes pale but maintains his position weakly. By the third textbook, he gives in and admits he screwed up the whole thing. Needless to say, the judge made it tacitly clear that he had no further interest in the expertise of that expert, and yes, we won. Moral of the story, don't use lawyers who only know the law. That guy's report had been seen by at least 4 and probably more lawyers on their team, and none of them had enough basic math to notice the error. Story 44. Not me personally, but it's a great story about how even the big guys screw up sometimes. There's a restaurant in Ireland called Supermac. McDonald's super unhappy about this since it sounds kind of similar to their Big Mac brand. Luckily, McDonald's have a trademark for Big Mac, and that trademark covers both food and restaurants. There's a bit of useful legal knowledge here. A trademark is only valid if you can show genuine use of the mark within the last 5 years or if it was filed less than 5 years ago. Also, in most cases, a trademark only covers the goods and services it is registered for and is only valid to the extent that it has been genuinely used for those goods and services. So McDonald's are facing a bit of an uphill struggle here. They have the trademark for Big Mac, but can only really show use for the actual food, not for the restaurant name. What should have happened at this point is that they prove use of Big Mac for food, try to argue for the restaurant use, but fail. It gets limited to just covering food, and Supermac get a notable but not newsworthy win. What actually happened was that McDonald's get into the IP law textbooks, but not in a good way. Their filing is a laundry list of everything that doesn't count to prove genuine use. They file drafts of advertisements, but with no indication that the adverts were ever published. They file statements from high-up execs which aren't detailed enough and which are generally not considered persuasive anyway. They file sales reports which don't actually show that Big Mac was a name presented to the customers. They file a couple pieces of evidence that might have worked, but they're from more than 5 years ago, so they don't count. All they had to do was get a lawyer to walk into any McDonald's with a camera, take a picture of the menu plus some additional statements around that, and preferably a few different McDonald's to show use across the territory, but pretty much that simple. Hell, the lawyer could have even bought a burger and eaten it while they were there, and that would have helped their case. They could have billed the cost of the meal to the client as well. Everyone in that courtroom knows what a Big Mac is. However, the court only knows what is presented to it in evidence, and McDonald's have just failed to prove that they ever advertised or sold a burger called a Big Mac. So the trademark is deemed invalid for lack of use across the whole EU. The next day, Burger King have a new menu featuring items such as like a Big Mac but juicier and like a Big Mac but actually big. McDonald's refiled the trademark in pretty short order, so it didn't last long. I can't think of a bigger legal fumble than McDonald's failing to prove they own Big Mac or use Big Mac. That is hysterical. Opie's right. It is a great story about how even the big guys screw up sometimes. Story 45. So at least where I live, gifts given in contemplation of marriage are conditional on the marriage actually taking place. So practically, if I give you an engagement ring and you break off the wedding, you have to return the ring. You might get to keep it if I'm the one to break it off, though. This is one of those patterns they teach in law school as a silly, relatable situation that gets you used to reading law but will never come up in real life. Well, it came up. Someone was charged with robbing his ex-fiancée by demanding the return of a ring at knife point. Well, robbery requires at least an attempt to steal, and it turns out it was his ring. It didn't matter in the end, since he convincingly denied it ever happened, but it was a strong plan B. Story 46. Used to work with lawyers, this is the best one I heard. I think this guy should have been found guilty. Driver pulled over by County A police, but the stop went over county line to County B. The person blew a 16, had ice coke and weed on him. plus no proof of insurance. Person was arrested, etc. Lawyer went to County A court and pled guilty to the no proof of insurance. Asked how he pled on the other cases, and he said he would like to go to trial for those. Court said, okay, that's fine. Next week, lawyer calls up court clerk. My client was arrested in County B. This means County B should be the one that handles the case. Clerk said, sounds fair, I'll transfer the case. Court date comes up in County B. Lawyer comes in. Double jeopardy. My client already pled guilty. Judge agreed. Client got a $40 ticket and had to prove he had insurance at the time of the arrest, which he did.